Good morning.
Good morning, Judge.
Good morning, my lady.
You may call up the matter.
Thank you, my lady. As the court pleases, my lady, this is a matter between LNG Scientific, Pty Ltd, and the Special Investigating Unit and one other, case number GP03 of 2022, appearing before the Special Tribunal of South Africa, before Madam Justice Modiba, 15 June 2023. My lady.
Thank you. Counsel may place themselves on record.
As it pleases, my lady, I am Advocate Laletwa. I appear for the applicant in this matter.
Thank you.
My lady, I'm Advocate Andrew Breitenbach. I appear with my learned friend, Advocate Sibonile Koza, for the respondents in this matter.
Thank you.
Thank you, my lady. May I proceed?
Yes, you may.
Thank you, my lady. Well, my lady, the facts in this matter are largely common cause, and your ladyship is well familiar with this matter, and so I will not repeat nor regurgitate the issues covered in our heads of arguments. Where I would like to start off, my lady, is with the order of 3 February 2023. The tribunal on that date made a finding. The tribunal found that there is no proper appeal before the full court. Consequent upon that particular finding, the tribunal then gave an order that directed that the main review be disposed of in the second quarter of 2023. However, my lady, unbeknown to the tribunal at that time is that 2 days prior to handing down its judgment and order on 3 February 2023, the registrar of the appeals court in the High Court of Pretoria had issued and sent out a notice of setting down the appeal. So that set down, my lady, can be found on case line 026-27. It was emailed to all parties involved in this matter. It could not have been brought to the tribunal's attention, I guess, and it wasn't brought to the tribunal's attention. And so at that point, when the tribunal held that there is no proper appeal pending before the High Court, my lady, we submit that finding was incorrect. There was indeed, as a matter of fact, an appeal pending before the High Court, and that appeal has been set down, and it had been set down even at the date that the tribunal found that it was non-existent. And so on that score, for that and other reasons.
But Mr. Saletwa, that finding was not in a vacuum, right?
Yes.
It was on the basis that the appeal was brought out of time. So the condemnation question is before the appeal court. And that's really what I meant there.
Yes.
So I didn't mean that in effect there isn't an appeal that has been filed. So I meant that whether that appeal is properly before the appeal court is an issue that still has to be determined. That's what I meant. And that issue remains.
Well, my lady, the condemnation application remains to be dealt with by the full court.
Exactly.
Yes. And consequent upon that particular finding, there's a possibility that the appeal court may grant condemnation and grant the appeal on the merits thereof. Or there's a possibility that the appeal court may dismiss the condemnation, in which instance then there's no appeal at all.
So the fact that the appeal has subsequently been enrolled is a really of no moment, because the condemnation question remains outstanding. That has always been the case.
Yes.
So the fact that I wasn't aware of the enrollment when I granted the February order is inconsequential.
Well, my lady, that then brings me to the reasons why the second appeal was noted. Because pursuant to the finding of your ladyship that there's no pending appeal, and pursuant to the finding of your ladyship that the tribunal is not convinced of the merits of the appeal and the prospects of success with that condemnation, the tribunal then ordered that this matter be disposed of. And we say that such an order that says that it must be disposed of in the second quarter is final in effect, because the net effect of it is it renders the pending appeal moot, it renders the condonation application moot. It effectively pulls the rug from under our feet. If your ladyship's order were to be carried through, and if the main review application were to be disposed of in its entirety in the second quarter, what then do we say to the appeal court when we get there on 15 May 2024? The first question they're going to ask us is, listen, any court exists to resolve life disputes. Where is the pending controversy here? And there would be none, because the matter would have been disposed of. And we say that by virtue of that eventuality, your ladyship's order is final in effect. And that then necessitated the second appeal. And we now know, my lady, at a level of fact, that both the first and the second appeal have been set down. Both of them are going to be heard on the same day. Now, the SIU and the MEC contend that the second appeal has not been set down, but we've attached screenshots from case line to our papers at case line 026-25 that shows that even the second, my lady, I'm not certain if you, oh, sorry, I thought you had frozen there for a moment. I apologize, my lady.
That's fine.
My lady, we have appended to our papers a screenshot from case line that shows clearly that the second appeal is equally set down. And my instruction from my attorney is that when he filed the appeal, the registrar informed him as much that because it's the same parties, more or less the same issues, they are going to set it down on the same date. So both appeals, as things stand now, as a matter of fact, are going to be heard on 15 May 2024. And that then brings us to the crisp question for determination before the tribunal today. And that is it irregular for a party to want to proceed by default judgment to dispose of a matter under circumstances where an appeal has been noted and that appeal so noted is set down for hearing? My lady, we submit that it constitutes an irregular step. It constitutes an irregular step because it does away with the pending appeals. It renders them moot. It preempts the outcome of the appeal court. The SIU and the MEC contend, my lady, that the 3 February 2023 order is interlocutory and so not susceptible to an appeal. My lady, we submit that that contention is incorrect for two reasons. One is it for the SIU and the MEC to make that determination themselves, to say it's interlocutory, we are ignoring the appeal that has been noted? They contend that it is so, but my lady, we place heavy reliance on a case that we quoted in our heads at paragraph 18 of our heads of argument. That said, case line 027-5. It's a decision that came out recently on 5 May 2023, a month ago. And the Supreme Court there equally dealt with an appeal to an exception, essentially. But the difference there is it went to the granted. And my lady, the Supreme Court said squarely that the scheme of Section 18 is simply to allow for different suspension regimes of the application to decisions and interlocutory orders. The provision has nothing to say about when an interlocutory order might be appealable. Only that if such an order is sought to be appealed or leave has been given, rightly or wrongly, the Supreme Court says, Section 18.2 is suspension of the order. Section 18 does not overturn the court's jurisprudence as to when a decision is appealable. Now, premised on that authority, my lady, we say that the age-old authorities as to when an order is appealable remains, even if your ladyship is in agreement with the SIU and the MEC of Health that this is an interlocutory order. The authorities still remain. It isn't for any party to look at Section 18.2 and say, well, because of Section 18.2 is interlocutory. That decision doesn't vest with the SIU, and neither does it vest with the MEC. My lady, the authority that we rely on for that proposition is quoted in our heads at paragraph 26 and 27. At paragraph 26, my lady, it's the age-old Zweni versus Minister of Law we are all familiar with the Sweeney triad, the three elements that have to be necessary to render an order appealable. But at paragraph 7, with reliance on Cronshaw versus Coin Security, is also a 1996 SDA case, my lady. The full citation is 1996, volume 3, SA 686A at 690D, where the Supreme Court says, the question is intrinsically difficult, and a decision one way or another may produce some unsatisfactory results. There has to be a rule, however, and that rule was laid down by not later than Pretoria Garrison case. So this is in reference to the 1948 case, and this is what the Garrison case says. Unless it is, it says that a procedural order is an interlocutory order and not appealable, unless it is such an order that it disposes of any issue or portion of the issue in the main argument. It amounts, I think, to the same thing, unless it irreparably anticipates, or, and this is where we stand for our case, or precludes some of the relief which would or might be given at the hearing. My lady, in the event that the tribunal agrees with the SIU that it's an interlocutory order, we still contend that it's an interlocutory order that is final in effect. And we say it's final in effect because it precludes, on the test of Garrison, it precludes the attainment of LNG of some of the relief that is being asked for in the appeal court. And that naturally would come from what I stated in my opening address, my lady, that the first question that the appeal court is going to pose to us is, where is the live controversy? And if we cannot present the live controversy before the appeal court, we are precluded from obtaining any relief that we are going to seek there. And so any order, particularly the 3 February order that disposes of this matter, precludes the attainment of any relief, and it is on that score final in effect. My lady, we then present an argument in our case on the prejudice that the party is going to suffer, and I do not intend to repeat those arguments. They cover from paragraph 32 all the way to paragraph 57. My lady, we submit that in as far as any party's entitlement to a fair hearing, that entitlement includes approaching the appeal court for the more than to fully ventilate and argue your case. And this is what the Supreme Court also in December found is against society, where an attorney that had been suspended was slow in prosecuting an appeal. The LPC then went to court for the striking out. The judge dealt with that matter. Well, the judge first denied Mr. Samuels a postponement and then dealt with the matter on the papers, and the Supreme Court said no, it cannot be. Every party is entitled to a fair hearing before any court. We say that a fair hearing would be offended if we go to the appeal court with nothing to fight over. If this matter is disposed of now, today, there would be nothing to fight over before the appeal court. And we know that the set-down was communicated in February, and that offends LNG's entitlement to a fair hearing before any forum. My lady, for the rest of the submissions we stand with was contained in the body of our application and in our written submissions. Those would be my submissions, my lady.
Thank you, Mr. Breitenbach.
Thank you, my lady. The issue for decision in this application is whether the Special Tribunal's judgment of the 3rd of February 2023 is, as our side contends, a decision that is an interlocutory order not having the effect of a final judgment governed by Section 18, Sub 2 of the Superior Courts Act. The wording is a decision that is an interlocutory order, that's the one element, not having the effect of a final judgment. The Special Tribunal's judgment of the 3rd of February concludes directives regarding the delivery of papers, argument in the main case, and regarding the date of the hearing of the main case. There is, we submit, no doubt that the directives are an interlocutory order. They regulate the procedure in the main case so as to make it ripe for hearing. The question is, do the directives and the reasoning of the tribunal in the judgment leading to the directives have the effect of a final judgment? And the answer to that question may be, and that's on the authorities to which we shall briefly refer you, and whichever of the three ways is adopted, the result is the same. The conclusion is to applies. The first approach was applied by Justice van der Linde in Transnet Second Defined Benefit Fund versus Regiments Fund Managers Pty Limited and others. The citation is given in our heads. It's a very long judgment dealing with a number of matters. The key paragraphs for present purposes are paragraphs 111 and 112. They are at case lines 028-284. And this approach was also discussed by Justice Sutherland for a full court in the matter of KMR versus KR, paragraphs 11 to 12 at case lines 028-55. The first approach presupposes that a final judgment means a judgment on the main case or on any issue or portion of an issue in the main case, or which amounts to the same thing, a judgment which irreparably anticipates or precludes some of the relief which would or might be given at the hearing of the main case. And my learned friend this morning, quite correctly with respect, referred your ladyship in that regard to the well-known description in Pretoria Garrison Institutes versus Danish Variety Products, Pty Limited, 1948-1, SA 839A at 270 of interlocutory orders, which at common law are nevertheless appealable. He also quite correctly referred your ladyship to the Zweni triad. That's Zweni versus the Minister of Law and Order, 1993, Volume 1, SA 523, Appellate Division 531I to 533B, which on this aspect required that the order must have the effect of disposing of at least a substantial portion of the relief claimed in the main case. So to up the bar slightly, it's a substantial portion. As to the application of this standard to the facts of the present case, we, however, part company with our learned friend. Submission is, firstly, that the issues in the main case are whether the MEC's decision to contract with the LNG for the PPE should be reviewed and set aside. And if so, whether resulting contract and purchase orders should be declared invalid, and further, whether LNG should be directed to repay all or part of the money it received for the deliveries of the PPE it made. Our point is that neither the reasoning of the Special Tribunal in its judgment of the 3rd of February 2023, nor any of the directives it consequently issued is a final judgment described. Neither the reasoning nor the directives, in other words, deal in any way with any issue or any portion of any issue in the main case. That brings me to the second approach. It was also one which was raised in and was in fact applied in the Transnet Second Defined Benefit case at paragraph 111, case lines 028-284. This approach focuses on the aspect of finality. It presupposes that a final judgment is one which, regardless of whether it concerns the main case or any part of it, is not susceptible to alteration by the court or tribunal which gave it. Now, as the tribunal will know at common law, One of the identifying features of a purely interlocutory order, as distinct from an interlocutory order having the effect of a final decree, is that a purely interlocutory order can be varied by the judge who made it or by another judge of the same court, provided, of course, this is done before final judgment in the suit is pronounced. As authority for that not cited in our heads, we refer respectfully to the well-known Bell versus Bell, 1908, TS 887. Thus, as was explained by the SCA in Aitken versus Botha, 2011, 6 SA 231, paragraph 12, that's at case line 028-14, applying this principle, a common law interim interdict or attachment pendente lite may be ameliorated, in other words, it may be varied or even set aside by the same court if the practical experience of its operation indicates that should be done. Turning to the facts of the present case. Nothing has prevented the special tribunal from varying the directives should the practical effects of the implementation or supervening events indicate that should be done. We've given an example of a situation where that could have validly have been done in the period between the 3rd of February and today. It's in paragraph 17 of our heads at 027-31 case lines. The third approach was applied by Justice Binns Ward in Velocity Trade Capital Pty Limited versus Quick Trade Pty Limited and others. That's South Africa SA 986 Western Cape Court at paragraph 65 to 67. Again, a long judgment and only those limited portions relevant. They're at case line 08028-315. There, His Lordship, relying on Nklemeza versus the Helen Suzman Foundation and another, 2017 Volume 5 SA 402 SCA, paras 20 and 25. And one finds that at case lines 028-100 to -102. Now, this approach presupposes that Section 18.2 is directed at regulating the position in those exceptional cases in which an appeal is permitted against a purely interlocutory order. And that is because of a grave injustice which cannot be prevented in any other way. Here, in our respectful submission, the tribunal's directives have not given rise to an injustice, let alone one which cannot be remedied by an appeal at the end of the main case. We make 3 points in this regard. First, at any stage between the 3rd of February and today, LNG could have delivered its answering papers in the main case, together with an application for condonation of their late delivery, albeit with the reservation of its rights in this irregular step application. If LNG had done so, and if pursuant to today's hearing, the special tribunal were to dismiss the irregular step application, the special tribunal would be at liberty to then grant the application for condonation, fix a new timetable for the delivery of the replying papers and heads of argument in the main case, and fix a new date for the hearing of the main case. That brings me to my second point, which is an answer to the mootness point raised today. As to the argument that the 3rd February 2023 judgment and directives renders the appeal moot, we respectfully submit that is not right. The reason is this. If LNG loses the main case, one of the grounds it may raise in an appeal as of right to the full court under Section 8.7 of the Act is that the special tribunal was wrong to require it to file answering papers and heads and hear and determine the review, while its application for condonation for the late filing of its appeal against the tribunal's decision of 29 June 2022 was pending. Your Ladyship well knows that the main procedural problem that LNG has raised is that it believes it was wrongly denied a Rule 53 record. even those we have indicated in the papers, and your ladyship has pointed out before, it has received the equivalent of the Rule 53 record through the combination of the annexures to the founding affidavit and the discovery made in November last year. So we regard the prospects of success of any such point as being very poor, but the point is they may raise such a ground of appeal. Secondly, in paragraph 27.2 of the answering affidavit of my clients in the irregular step application at case line 025-33, they went further and they said, if the special tribunal grants default judgment in their favour, and if LNG were later to succeed with either its intended appeal against the tribunal's decision of 29 June 2022 or its appeal against the special tribunal's decision of 3 February 2023, my clients will consent to the full court remitting the main case to the special tribunal in order for LNG to, for them to deliver a record, obviously, in terms of Rule 53 if applicable, and thereafter LNG to deliver its answering papers, and so on. So with respect, my lady, there is no question of the of any mootness arising in relation to the procedural points which LNG has seen fit to persist with in this matter. Our submission, therefore, is that the irregular step application falls to be dismissed with costs, including the costs of a senior and a junior counsel. Finally, maybe I be permitted to make brief submissions as to the way forward. I would respectfully refer the tribunal to two documents in the record. The first is the directive which the tribunal gave on 19 April this year following the judicial case management meeting that day, and specifically paragraph 5.2 of the directive. It reads, the registrar is directed, 5.1, to enrol the irregular step application for hearing by the special tribunal on the first mutually convenient date in June 2023. I interpose to say that that is what has happened. The irregular step application has been so enrolled. And further, 5.2, to enrol the main application for default judgment on the same date, on the basis that the main application will be dealt with only if the irregular step application is dismissed. Otherwise, i.e. if the irregular step application is upheld, the main application will be removed from the roll to await the judgment of the full court of the High Court, pursuant to the proceedings on 15 May 2024. Now that is in the judgments and orders part of the case lines bundle at 18. The second document to which I respectfully refer you, milady, is at 025-19. It is a notice of set down, which was delivered on the 15th of May by my instructing attorney, Masandi. It was for the set down today of not just the application in terms of Rule 32B, the irregular step interlocutory application, but also B, upon LNG not being successful with its irregular step interlocutory application, the application for default judgment in the main proceedings brought by the SIU and the MEC. And that set down notice was delivered pursuant to paragraph 5 of the directive. Against that background, we respectfully make the following submissions. If today, having heard the oral argument, the tribunal decides that the irregular step application falls to be dismissed, then we respectfully ask that the tribunal make a ruling to that effect, with or without giving reasons, and then proceed immediately to hear oral argument on behalf of the SIU and the MEC in the support of the granting of default judgment, which I can assure you will be brief. We respectfully submit that doing so will give effect to the tribunal's directive of 19 April, and it will save time and avoid the incurrence of further costs by the SIU and the MEC. Those are our submissions.
Mr. Breitenbach,
Yes,
I'm
madam.
minded to proceed differently in respect of the proposal that you've just made. I don't intend ruling on the irregular step application today, because I prefer to articulate the reasons together with the order, when I hand down the order. So to deliver judgment. However, the directive that I gave remains effective. So the default judgment application is on the roll today. So what I intend doing is to consider it on the basis of the papers and actually hand down one judgment in respect of both applications. If there are issues that you would like to argue in the default judgment application, I will give you an opportunity to do so today.
Thank you, Milady.
However, in the event that the irregular step application proceeds or succeeds, I will simply remove the default judgment application from the roll. But I intend handing down one judgment.
I'm indebted to your ladyship. That will address the overriding concern from our side concerning the saving of time and the avoidance of the incurrence of additional costs.
Yes, so I'll hear Mr. Hlaleto and reply, and then if you'd need to address me in respect of the default judgment application, I'll give you an opportunity to do so.
Thank you, Madam.
Thank you. Mr. Hlaleto?
Thank you, Milady. Just three issues in reply, very briefly. Milady, my colleague for the respondents says the decision to be made by the tribunal today is whether or not the order is interlocutory or final in effect. Milady, we still contend in the alternative. This is the secondary argument that we presented in our papers, that normally, under normal circumstances, a judgment is rendered down. A party then files an application for leave to appeal. In filing that application for leave to appeal, the court of first instance that has the ability or the discretion, or that is vested with the power to make a decision as to whether they grant leave to appeal or not, says to a party, I am not granting you leave to appeal because your application is, because the order is interlocutory. In this circumstance, however, we are dealing with an instance where there is an automatic right to note an appeal. We are dealing with an instance that is similar to when leave has been granted by the court of first instance. And on that score, we submit that it cannot be for the tribunal to then revisit its order, step into the space between the order and the automatic right that exists by virtue of Section 8, and step into that space and says, I am telling you that I'm not granting you leave because this is interlocutory. If any party wants to proceed on the basis that the order or the appeal so noted is interlocutory, they have Section 18.3. You bring a declarator in terms of Section 18.3, and you say that suspend the, give effect to the operation of the order, because if you do not do so, I will suffer irreparable harm. This is not what the SIU did. And we say in our papers that not doing so was fatal to their cause, because now the issues have effectively moved away and out of the ambit of the tribunal. They are squarely vested within the ambit of the appeal court. It is for the appeal court to say, I am striking this appeal off the roll because it's not an appealable order. As was done by the Supreme Court recently in May in the TWK Agriculture judgment that we refer to, the parties were granted leave by the full bench to the Supreme Court. The Supreme Court said, listen, the authorities are clear. The dismissal of an exception is not an appealable issue. We are striking this thing back. We are striking this thing off the roll and sending it back. Now, my lady, we contend then under these circumstances that it cannot be for the tribunal to make a determination that the order is interlocutory or final in effect. We have an automatic right of appeal. We've noted that appeal. absent an 18.3 application to suspend, rather to give effect to an order pending the appeal so noted. Absent that application, the SIU we submit made a fatal error. My colleague then said that there is no injustice that would occur should the irregular step not be granted and default judgment granted. And he makes reference to the fact that we have been given all the documents that we need. My lady, you would recall that the SIU's initial stance was that we've given you all that we have. It's attached to our papers. If you want anything more, it is incumbent upon you to identify anything more that you want and to tell us, and we'll try and find it. Fortunately, and that's what necessitated the application, whether we have to get everything by virtue of Rule 53 or 35. We were fortunate enough, LNG was fortunate enough in these circumstances, in that it was able to obtain papers that were filed in the Constitutional Court, where under oath one of the parties was saying there was a meeting held on this day where a determination was made that X amounts of PPEs are required. There was a meeting held on this day where determination was made that a particular person is empowered. There was a letter of authority that authorized another person to procure PPEs for a certain particular amount. And once we put those in our replying affidavit, the SIU gave us those documents. Now, we were fortunate in that scope. Now, what of all the other parties that come as respondents in self-review applications? The SIU attaches 3 documents to his founding affidavit and says he or she acted without authority. These are the documents that we have. There's nothing that gives them authority. What happens to another party that is not so fortunate to obtain papers in different tribunals, in different forums? Because, my lady, the only reason that they filed the documents that they filed is that we were able to identify them. We were able to identify them because we knew they existed. And now this is exactly what Rule 53 seeks to avoid. It seeks to avoid a respondent having to scuttle around and search for what documents. It says at the outset, give them everything. And we say that, my lady, it's a significant argument that we intend to present before the appeal court. And the tribunal, the SIU and LNG have already gone through the debate of the significance between Rule 35 and Rule 53. And so I will not re-argue that case. But my lady, of significant import is this. LNG has not filed an answer because it adopted a legal position that it is unable to find its answer until it has been provided with a complete record in terms of Rule 53. That record has still not been submitted as a complete record in terms of Rule 53. That argument remains pending before the appeal court to be deliberated upon. Now, my lady, if, as my colleague now proposes, if we succeed with the appeal, my colleague proposes to the tribunal now that if we succeed with the appeal, they would have no objection to remitting the matter back to the tribunal and essentially restarting the entire process. That can never be cost effective. That can never be efficient. And if I may then answer on that point again, my lady, once a tribunal renders a judgment, it becomes functus officio. So once a tribunal says, I am granting default judgment on the main review, it becomes functus officio. That is a fact. The issue that is pending before the appeal court deals only with the record. So once we succeed with the issue concerning the provision of the record, on what basis would anybody reopen the judgment on the main review? There would be no basis for that until a third appeal lies as against the main order from the main review. And so with respect, when the SIU says, well, if we are successful now and they tend to be successful at appeal, we will consent to the reopening and the remittal of the matter. My lady, that is very unhelpful because the appeal court would not be dealing at all with the main review. They would only be dealing with whether or not we are entitled to the record. And if they say we are entitled to the record, it would be a hollow victory it would be a court order that would not be given effect to, because we would stand with a court order that says we are entitled to the record, but to use the record where? Because the main review is gone, and absent an appeal, nothing reopens it. And so that is why we say that the order, my lady, that says dispose of this main review in the second quarter is final in effect, because it essentially closes the door, and it renders the argument coming next year moot. My lady, we then submit that in the event that we are successful with the irregular step, that the default judgment application falls to be set aside, and it falls to be set aside with costs. My lady, those
Mr. Feleto, I would have expected you, in your attempt to persuade me that if I dismissed the irregular step application, you would be prejudiced in the sense that you do not have the record. Then I would be persuaded that you are prejudiced, right? You have not said to me that you do not have the record. What you are saying is that the record has not been furnished to you in terms of a particular rule. It was discovered. It wasn't filed in terms of Rule 53. That does not establish prejudice. That's your difficulty, not only here, even in the appeal court where you're going. That difficulty, I've already ruled that you've got serious difficulties with the practical effect of the first judgment, not even the February judgment, with the practical effect of the appeal against that judgment. And that difficulty faces you even today.
My lady, if I may.
You've had ample opportunity to study the discovered records, discovered documents, and tell me in what manner you remain prejudiced that a record in terms of Rule 53 has not been furnished to you. You've not done so.
Yes.
So I'm not persuaded that you couldn't answer.
My lady, it's not that
you have elected not to answer. You have elected on this litigation strategy that you've embarked on. And so far, all it's proving to be is dilatory.
My lady, if I may, there is a principle in our law, the principle of preemption. If a court grants an order and you comply with that order, you have preempted. You cannot then proceed to appeal. So as it happened here, the court grants an order, says, listen, you are not entitled to a record in terms of Rule 53. You are entitled to discovery in terms of Rule 35. We note an appeal. After noting an appeal, a discovery is given. We say that we cannot take any further steps because we cannot give effect to a court order that we've noted an appeal against. That is the basic principle of preemption. So on that basis, we could not have done anything. Otherwise, that would have undermined our own appeal. Otherwise, that would have meant that we are discarding and abandoning our own appeal. We still stand by our arguments that was noted in November last year, my lady, that the record falls, and it's not just for LNG as we've contended. It's for all practitioners that come to the tribunal, because your ladyship's judgment is precedent setting. It essentially says that in any self-review, nobody is entitled to the record in terms of Rule 53. You are entitled to the record to be discovered in terms of Rule 35. And we say, because it's the only decision, it's precedent setting. And it comes from the judge precedent. So naturally, everybody would follow it.
The substance of your right is the right to a record. And that right has been realized.
Well, my lady, that's where the Mamadi judgment, we say, differs with the finding of the tribunal.
Okay, let's not go into the merits of the appeal. Let's not go into the merits of the appeal.
Yes, Maledi, that is exactly my point. That is a decision to be, that is an issue to be argued before the appeal court. Nothing prohibits the SIU from saying to the appeal court that the record that they're asking for, be it 35, be it 43, has been provided, and here it is. It's a
but
decision.
They've said so. They have said so. Even here, they've said so. Yes.
Yes, but we are saying that it's an argument to be had at appeal, not here. Okay. Because the judgment was rendered, an appeal was noted, and then they discovered the record after the appeal was noted.
Okay.
So it's a debate for the appeal court. As things stand today, the issue before the tribunal it's a crisp and very simple one. Can you proceed by default judgment under circumstances where an appeal has been timeously noted, and an appeal so timeously noted is set down for hearing? There is this crisp, simple issue. Do you ignore whether there's an appeal and there's a set down? At a practical level, that's what it amounts to. And my lady, we say that the tribunal cannot ignore that an appeal has been noted, cannot ignore that the appeal has been set down. And if anybody wanted to proceed pending the appeal that has been noted, they ought to have invoked Rule Section 18.3, and the SIU did not. And those are our submissions, Marie.
Thank you. Judgment is reserved in the irregular step application. Thank you, Mr. Hlaletwa. Mr. Breitenbach.
Thank you, my lady. If I may be permitted one sentence on a new matter raised by my learned friend. The issue of preemption. He contends for the first time, it's not in his client's papers and it's not in his heads, that the reason why they haven't studied the record, prepared and delivered an answering affidavit is that they are worried that by doing that they would be preempting their appeal. It is elementary that parties who stand on an issue of principle like that are entitled to secure their position by, in this case, preparing and delivering an answering affidavit subject to a reservation of their rights in the appeal. As long as they make that clear, as one does when one pleads over, having taken a point of lack of jurisdiction in a special plea, there is no question of preemption. And so there's no inevitable obstacle to them having done what they've done. We have made our submissions as to our concerns about this being a play for time. My lady, on the main matter, we have filed lengthy heads of argument, and I do not intend taking your ladyship through them. They are at 006-0a and following of the of case lines. I wish to address briefly two issues only. And if I could ask your ladyship to go into case lines to 006-0AN. It's the...
Which document are you taking me to, Mr. Breitenbach?
To our main heads of argument in the main case.
Paragraph, you can give me the paragraph.
Paragraph 54, just under the heading Grounds of Review of the Impugned Decision.
I'm there, thank you.
Lady, as you will know, there are 4 sets of grounds of review set out in paragraphs 55 and following. What I wish to address you very briefly on is a curious feature of this case. And it is that just before the long weekend in April 2020, as indicated in paragraph 55, Ms. Lekluenia took the impugned decision. It was on the 24th of April 2020. And at that stage, Treasury Instruction 3 of 2021 was the applicable instruction. When she communicated the decision, which occurred shortly after the long weekend, the day after the public holiday, the 28th of April 2020, a new Treasury Instruction 5 of 2021 applied. And in the chronology, we deal with the differences between the two. The essential difference being that Treasury Instruction 3 of 2021 provided for a central purchasing system, and government agencies which required PPE would go to the central purchasing agent of the government and acquire them there. The other one, 5 of 2021, changed completely. It did away with that. It allowed government agencies to procure for themselves, but then there were listed maximum prices. You will recall that, my lady. So we've contended in paragraph 55 for the reasons given there that what she decided was inconsistent with the central purchasing system requirement, namely because she went outside. That was when she decided it. We've contended in paragraphs 56 and 57. 56 lists what we submit are the presently relevant prescripts of Treasury Instruction 5, and in 57, one then has what the alleged contraventions of Treasury Instruction 5. Followed by that, the third ground of review spans both periods. It relies on Treasury Regulation 16A.6.4 and the alleged contravention attached to both her decision and her communication of the decision. And so does the fourth ground of review, which is in paragraph 60, which concerns a provision of the Public Finance Management Act and the COVID-19 regulations. What I wish to briefly address you on, my lady, is insofar as the first and second grounds of review put up grounds of review, one attacking the decision when taken, the other tackling the decision when communicated. An issue which we regrettably didn't deal with in the heads is which takes precedence. In other words, what happens in a situation where a decision is taken under one legal regime on day one and it's communicated on day two? And in that regard, we make the following brief submissions on the legal significance of communication of an administrative decision. In Baxter's well-known book on administrative law, which was published in 1984, at page 364, the learned author said, and I quote, "Empowering legislation often stipulates what form an administrative decision is to take. For instance, an official is sometimes required to notify the applicant of his decision in writing. Where no such stipulation is made, and that's the case here, the form which the decision is to take, written or oral, will vary according to the circumstances. The form the action will take will vary according to the provisions of the enabling legislation and the context in which it is taken. One important aspect, however, is notification, since those affected by the action must know about it." At the following page, page 365, the learned author adds that unless the enabling legislation specifically requires otherwise, publication of non-legislative administrative action in the Gazette is not obligatory. Finally, at page 366, the learned author repeats the importance of personal notification, and I quote, "Whether or not publication is required, it is nevertheless necessary to give any person who is directly affected by administrative action personal notice of the action taken, and when natural justice applies, notice of impending action. The notice must be given in a manner by which it's sure to come to their attention." Now, these statements by Baxter are in line with the following, or with a statement by the Constitutional Court in what's commonly called the SAFU case. That's President of the Republic of South Africa and others versus South African Rugby Football Union and others. 2000 Volume 1 SA 1 Constitutional Court at paragraph 4. And that statement was quoted by the Supreme Court of Appeal in the matter of MEC for Health, Eastern Cape and another versus Curland Investments Pty Limited, trading as Eye and Laser Institute, 2014 Volume 3 SA 219 SCA at paragraph 15. And the statement by the Constitutional Court, the case concerned the appointment of a commission of inquiry into rugby in South Africa, was that the appointment by the president of a commission only takes place when the President's decision is translated into an overt act through public notification. And it follows from that principle we submit that an administrative decision becomes operative when the statement of the decision is published, something which in the present case occurred on the 28th of April 2020. We draw that to your attention, my lady, because applying those principles, you may decide that it is appropriate to focus on the legal regime on the date when the decision was published and not the different legal regime when the date, on the date when the decision was taken. And if that is your ladyship's decision, then our first ground of review will fall away and our second ground of review will operate, together with the third and the fourth, which are apply irrespective of the dates in question. It is a difficult question, my lady, of law, and
It's not one I'm inclined to go into, because your ground of review servers, they cover all the grounds, right?
Yes, my lady.
And we all know that the superior courts would have actually urged me to rule on all the issues.
Yes.
For the benefit of that court when it considers an appeal. So that's not an issue I'm inclined to really go into.
As it pleases you. I just felt I needed to bring...
In fact, as you're arguing, what crossed my mind is if I were to consider, which Treasury instruction was operative, I would be inclined to rule that the first is operative, because the nature of an administrative action is relevant in determining when does an administrative action become effective. Because here, we're not dealing with an administrative action such as the one that was at play in SAFU, right? The administrative action here, the important elements of it are the determination of whether a bid meets the prescribed requirements.
Yes.
So given that Ms. Lehlenya applied her mind to LNG's proposal when Treasury Instruction 3 was operative, I'd be inclined to find that that's the one that was applicable, and not the one when she communicated, because there's no basis for me to find that before she communicated her decision, she actually applied her mind to the applicability of the subsequent Treasury instruction.
Yes, we have absolutely no evidence from
But
her.
I don't even have to go there. I really don't have to go there, because I'll rule on all the grounds of review that you rely on.
Thank you, my lady. One last wrinkle on the facts is that she clearly took the decision. She considered this bid. She decided that to make a proposal effectively, because she didn't accept some of the pricing and the quantities. That was on the 24th. On the 28th, she sent her the letter to LNG. A few minutes later, she appeared to have changed her mind on the different the sizing of the non-sterile gloves. So she changed the sizes and sent a second letter. But I leave. Oops, my lady, are you still there?
Yes, I'm here.
Thank you. Yeah. I'll leave it at that. The second point and last point that I wanted to raise with you concerns the just and equitable relief. May I ask you to go to paragraph 72? And
yes.
That starts obviously with the reference to section 172 1B of the Constitution and what have you. So the legal submissions are made in 72 and 73, the foundation. What one has in paragraph 74 and 75 are what are the different metrics which inform the various permutations for the order sounding in money, which is sought in paragraph 3 of the notice of motion. And milady, there's really a matrix which looks like this. In relation to the KN95 masks, if you take the data, which is 74 and 75 together, the difference between the maximum permitted price, that's by the Treasury Instruction number 5 that was applicable on 28 April, and the price which the department paid, that is 8.855 million. One sees that in 74.1. The difference between the permitted price and the contract price in relation to the three-ply masks, that's 5.5 million. One sees that in 74.2. And the difference between those two in relation to the non-sterile gloves at 74.3, that's 39.481 million. One sees that at the end of section 74.3. At paragraph 75, a different sum is done, and that is the price which the department paid, less the prices which LNG paid for the gloves which it purchased and on-sold to the department. Your ladyship will recall that the LNG suppliers' invoices were obtained and attached to the papers. So one has a different set of differences there. In other words, that's LNG's profit calculated on that basis. And in relation to the KN95 masks, it's 13.193 million. The three-ply masks, it's 11.310 million. And in relation to the gloves, it's 21.194 million. And what I wish to point out to your ladyship is this, that if one looks at those two numbers in respect of each item, so let's take the KN95 masks, which is the higher, LNG's profit or the difference between the maximum permitted price and the price paid? It's the profit, because that was 13.193 million, and the difference between the two prices was 8.8 million. The same applies to the three-ply masks. The profit is 11.3 million. The difference between the price paid and the permitted price, 5.5 million. But that is reversed in relation to the cheap non-sterile gloves. There, the difference is 39 million is the price, and the profit was only 21 million. And the point that I wish to draw that to your attention, because as your ladyship has probably been able to work out, the relief sought in paragraph 3.1, which is our first bid, as it were, is the addition of the three biggest differences: the two profits for the KN95 masks and the three-ply masks, and the difference between the permitted price and the price charged. Now that may cause concern on your ladyship's part, because effectively, in relation to the non-sterile gloves, LNG will be required to repay more than the profit that it made, roughly 18 million rand more than the 21 million profit that it made. And your ladyship will have seen from the section of our heads in which this is justified in paragraph 77, that privileging or giving preference to the contravention between the permitted price and the contract price in respect of the gloves over the profit made on the gloves is, in our submission, justified, because firstly, LNG did something which on the papers is very bad for it, and particularly for the department. It contracted to provide expensive sterile surgical gloves and provided cheap non-sterile examination gloves instead. So there's contractual malperformance. Every delivery is hit by that. That's the first thing. And if one looks at the maximum permitted price, that non-sterile examination gloves for them, that is 46 Rand and 44 cents, including VAT, for a box of 100. LNG is guilty of gross overcharging. It charged 270 Rand, including VAT. So that's the reason why in this limited respect, the relief that we seek, it's in paragraph 3.1, takes this court's jurisprudence on what is just and equitable one step further. It's a combination of disgorging the profits, that's the well-established jurisprudence, but in this particular case, where there was this breach of contract and gross overcharging, it will actually put LNG out of pocket. And I felt I had to draw that to your attention. Paragraph 3.2, one is dealing there of the notice of motion. One is dealing simply with the profits, the three profit amounts. And that is uncontroversial prayer, given your ladyship's prior judgments applying the all pay, no profit, no loss principle. We would obviously emphasize one thing here, is we understand the Mlangeni brothers' judgment of this tribunal, especially at paragraphs 23, 25, and 25.2.1. If, as it has done in this matter, the SIU proves the quantity of goods which LNG supplied to the department, and obviously the prices that were paid, LNG then bears an evidentiary burden to prove the reasonable expenses it incurred when supplying the PPE items to the department, and for which it's entitled to be compensated. Now, LNG has not put up any evidence. There's no evidence by LNG whatsoever. All that we have, and which LNG supplied, was the supplier invoices. During the course of the investigation, the SIU called for them and they were provided. And so what we do have is the prices. And the only thing I wish to draw to your ladyship's attention in relation to the no profit, no loss principle here is that the profit is calculated simply with reference to the prices at which LNG purchased the goods and the prices at which it sold them to the department. Other costs, as one sees in these couple of accountings, and I've read your ladyship's judgments in which you recount people coming along saying, well, we had transport costs, and then we've got certain fixed costs that they also want to include and what have you. There's no evidence of any of that. But my respectful submission, it's not incumbent on the applicants to put up that evidence. It's one of the risks of the litigation strategy to which your ladyship referred, my learned friend, of not putting up any evidence, is that they're potentially worse off when it comes to the no profit, no loss calculation. For the rest, in paragraph 3.3 of the notice of motion,
except that, Mr. Breitenbach, if the SIU is in possession with that evidence, I don't know if you read my judgment in the Ndlovu matter, where although Ndlovu had put up, a very elementary version at the last moment, he actually sought an opportunity to file a statement and debatement of account, right, which I denied him. But the SIU, in its analysis of his bank statements, was able to discern expenditure that Ndlovu and associated companies had incurred in supplying the goods. Obviously, in that case, it is incumbent upon the SIU to bring that evidence to the attention of the tribunal. So it's all it's circumstantial, really. Yeah.
It's in this matter, your ladyship knows there's a very detailed affidavit from an accountant, Ms. LaRue. It's one of the accompanying affidavits. It has all the relevant information.
I just need to adjourn for about a minute to put my device on a power source. Otherwise, it's going to go off.
Please, my lady.
Thank you, Mr. Breitenbach.
Thank you, my lady. So in this matter, Ms. LaRue's affidavit is in the papers, and if your ladyship is at all concerned about LNG being done in, may I ask that you have a look at the section of her affidavit in which she deals with the analysis of or the procedures performed in the analysis of the bank statements, the deposits, and so on. It's the affidavit starts at 001-143, and it is a very long affidavit. And from type page 23 of that affidavit onwards, your ladyship will find the section to which I've referred. Our submission is that one is dealing here fundamentally with just and equitable relief. It is discretionary relief, as the court made clear in the Trencon matter. So this is entirely within your ladyship's discretion. If your ladyship feels uncomfortable in the circumstances where LNG hasn't filed an answer, that it may be prejudiced financially because of that, the alternative, which is in paragraph 3.3 of the motion, is to issue the conventional declarator. That's if your ladyship wishes to opt for the divestiture of profits and rather this hybrid, which is the first claim. And there is a detailed, and it's the usual provision, although I recall at the time we drafted it, we did try and refine it a little, for providing for an accounting and an abatement. So that would be a way of dealing with it. There would be sufficient time for that to occur before the May appeal hearing, whereas your ladyship know the parties are in agreement that any and all issues arising from the special tribunal's consideration of this application and its determination will be placed before the judges of appeal. So that is an alternative option. The further alternatives in 3.4, which is claiming only the profits on, claiming only the two instances where the maximum price exceeded the permitted price. That's in 3.4, and then lastly in paragraph 4 is a referral to oral evidence or to trial of this question. I with respect, don't think that would be appropriate because we're not really dealing with a material dispute of fact here. There is no contrary version on the papers. So the options that, as I see them with respect, my lady, are orders sounding in money, paragraph 3.1 or 3.2, or a declarator that LNG be divested of its profits, and then the structured order for an accounting and an abatement of that. Those are the only things that I wish to draw to your attention in relation to our heads of argument, my lady.
Thank you. Judgment in the default judgment application is also reserved. Thank you very much for your assistance. We've come to the end of today's proceedings, and I adjourn the proceedings. Thank you.
Thank you, my lady.